Ms. Richards, if you'd like to do a quick sound check, and then we'll move over to Mr. Dickey, and then he can start after that.
Check, check.
Thank you very much.
Thank you.
Mr. Dickey, if you would please do the same, and then when we've got that confirmed, you can start with your argument. I don't know if you're on. I don't think you are. Can you push the button? That's right.
Testing 1, 2, 3.
Thank you very much.
You may proceed.
Madam Chief Justice, and may it please the court, I'm Gary Dickey from Dickey, Campbell, and Sahag Law Firm, appearing on behalf of Ryan Koster, who seeks reversal of the district court's orders granting summary judgment on his breach of fiduciary duty claim as well as his defamation claim. The court below committed two legal errors. First, Judge Fowler committed a clear legal error in applying the doctrine of qualified privilege to Mr. Koster's breach of fiduciary duty claims. Second, Judge Rydell committed clear legal error when he granted qualified privilege to the defendants as to Mr. Koster's defamation claim when the summary judgment record established that Pastor Glenn had communicated one of the emails to an individual who was no longer a member and no longer attending the church. Qualified privilege was also inappropriate on the defamation claim because the summary judgment record established a genuine issue of material fact as to the presence of malice, which is sufficient to defeat a claim of qualified privilege. With respect to the breach of fiduciary duty claim, in Banstra, this court established that the free exercise clauses of the federal and state constitutions prohibits the state from resolving an internal church dispute that requires a court to interpret religious practices or interpret religious doctrines.
I'd like to ask you a question about that. I understand, if the church has a practice, like in this case, to openly share information that maybe in another setting someone would think is not appropriate. So if that is understood, I want to make sure I understand, does the record show, or can you tell me the evidence about the defendant acknowledging that the statements were to be confidential? Is that understood, whether it's a church policy or not? Is that disputed?
It is disputed. There is a genuine issue of fact as to the expectation of privacy. What the record shows is that Mr. Koster and his wife split off into a group of 6 people called a life group. And the purpose of that is what he understood to be marriage counseling. Others understood it to be marriage counseling. At the beginning of the meetings, Pastor Glenn would say, this is a safe place. The conversations here will stay here. And admitted in the deposition, for example, that the whole discussion about whether or not they seek counseling at 12 Stones, for example, was something that he wouldn't be sharing with other members of the church. He just didn't think it was that big of a deal. So there's a genuine issue of material fact as to the expectation of confidentiality. And with respect to the issue of the religious practices of HBC, Harvest Bible Chapel, in terms of their open, biblical soul care and their open fellowship and plurality of leadership, that's really a manufactured defense that the defendants are asserting. You don't even need to get there because with respect to the doctrine of qualified privilege, they're not entitled to that because that privilege is limited to members of the church. And there is no dispute that Pastor Glenn sent an email to an individual outside of the church. So with respect to the Klebenstein decision, for example, that privilege has been abused, and therefore they lose that privilege. But even if
Counsel, can you clarify a fact issue for me? I assume when you say the email was shared outside with a member or a former member of the church, you're referring to Demarest, is that
correct? Jim Demarest.
Demarest.
Yes.
And I guess I was a little bit unclear on this record whether he still was a member of the church, whether he was attending, or whether he was somehow kind of informally involved in the soul care. So can you clarify the summary judgment record for me on that?
Sure. So Mr. Demarest and his wife were part of a small group, which was a kind of more, there were more people in that group that met for fellowship. And then Mr. Koster, Pastor Glenn, and the Martins split off into a life group, and they did that for approximately 2 to 2.5 years. So Mr. Koster was no longer meeting with the small group, including Mr. Demarest and the other individuals. What the summary judgment record says is it's undisputed that Mr. Demarest and his wife had left membership, were no longer attending the church at the time the emails were sent. Now, what defendants try to do is they try to broaden essentially the definition of church so that they can cover themselves with the qualified privilege by suggesting that Mr. Demarest was having email conversations with Mr. Koster, and therefore that's a sufficient interest that would warrant application of qualified privilege. And it just isn't. If you look at the Klebenstein decision, when you communicate something beyond the interest of the church and its members, then you lose that privilege. And because Mr. Demarest was no longer a member of the church and no longer even attending, they shouldn't be afforded qualified privilege.
If that's the only issue of fact, would you then have a trial just on whatever harm might have befallen your client as a result of disclosures to Mr. Demarest as opposed to the others?
No, because I think you lose the privilege altogether. I mean, Klebenstein doesn't say that you lose it just to the individuals. It says that the whole reason why we provide privilege is because it's necessary to perform some type of function. In this case, the management of the internal biblical soul care or their fellowship. But when you communicate it beyond that privilege, you lose it as to everybody.
So in that view, then, if the privilege is lost, the fact that it's only communicated to Demarest outside the church, that might be relevant to damages, but it wouldn't be waiver of privilege or loss of privilege as to Demarest specifically. It would be loss of the entire privilege.
It's loss of the entire privilege. So with respect to the issue of liability, they're not afforded that affirmative defense at all because that privilege has been abused. And so, yeah, perhaps they can make an argument, no big deal. We have the right to send this email to everybody else.
It just seems kind of illogical. I mean, if sort of there's a list of so many people he sends the email to, and he was privileged to send it to all but one, he sends it to one too many people, and then now your client is entitled to recover for any emotional harm suffered from the disclosures to any of those people. That seems not quite logical to me.
Well, it is, because if you have to go back and look at why we have qualified privilege in the first place, and that's the case law from this court has been clear that at first it applies only to defamation, not to negligence and intentional torts or breach of fiduciary duty. But the purpose is to shift the proof requirement for malice. So they can assert qualified privilege, and then the burden shifts to Mr. Koster then to prove malice. It's not intended to provide them with a complete defense. It never has been. And so when they abuse that privilege, right, then the burden no longer shifts to Mr. Koster to prove malice. But even if it did, the evidence is sufficient in this case to establish a genuine issue of material fact with respect to the issue of malice. But one more factual point that I want to put on the qualified privilege. You know, the emails that Pastor Glenn sent out said that, I'm not sure I should be sending this out. It's very sensitive, but use discretion when you share it with others. So there's another factual question, which is, there's evidence in the record that Mr. Koster's babysitter learned of it, actually third hand through an intermediary who learned it from the email. So there's evidence in the record that this was being communicated beyond the individuals who were the addressees in the emails.
Counsel, does that kind of blur the lines then between qualified immunity and the ecclesiastical immunity, or qualified privilege and the ecclesiastical immunity, for the church to be the one to decide how broad that group is that they're communicating with as part of the program that they're trying to encompass? Does that do you understand what I'm saying?
I don't think it does blur the line, because those two doctrines serve different purposes. So the religious immunity is to keep the court out from having to decide who's right in an church dispute.
Right, and I think that's my point, though. So in this idea about whether or not Mr. Demarest was technically a member or was still part of the group that was trying to counsel with your client, does that require the court to interfere with that determination?
Okay, so I see what you say now. I see what you're saying now, and I agree with you. If it was a circumstance where HBC took the position that the Demarists are still members in good standing because they continue to tithe, for example.
Yeah, well, but that's my point. Does it have to be that they're still members in good standing and continue to tithe, or is it just this person continued to be part of our group, whether or not he was continuing as a member?
All I can tell you is what the language this court has used in the Klebenstein decision, which is, members of the church. Anything communicated beyond that and the privilege is abused. In that case, it was essentially a petition for discipline that was sent to members of the local community, and that was sufficient. And the specific terms this court used was members, and so that's why that's been kind of what the fighting issue has been. At this case, at the district court level, is because Mr. Demarest and his wife were no longer members, and they do not dispute that. What they want this court to do is expand the scope of qualified privilege to seemingly cover anybody who's ever attended the church, regardless of whether they continue to participate or not, in any meaningful way other than some random emails.
Move over to the breach of fiduciary duty. So you're claiming there's a breach of confidentiality, and I think I'm in agreement with you. I was on the court when Banstro was decided that if there is a clear, neutral frame of reference, like the criminal law or a written contract that was violated, something that we can decide the case based on that is purely a secular standard, then you can pursue that claim. On the other hand, if deciding the claim involves, kind of considering, evaluating, mixing in, there's no clear frame of reference, and you have to look at church doctrines and church practices and what was regularly going on at the church, then the First Amendment becomes a problem. Why isn't this in the second category? Because reading the briefs, I don't see sort of a clean, clear, secular standard that you can rely on for your breach of fiduciary duty. So help me with that.
Sure. So I think it follows in two steps. First is there a fiduciary duty? And we think there's a genuine issue of material fact based on the nature of the marital counseling that Pastor Glenn was providing, okay? At least a fact issue. And then, so the second point of the analysis is then what is the actual duty? And we think there's another factual issue with respect to Pastor Glenn telling him, you come over here, what we say here is safe, right? What's said here stays here. In a small group, there's a policy that small group information is not going to be shared. The bylaws of the church itself say that there's a non-gossip policy. And so what Pastor Glenn... Right. So here's what I would tell you is if Pastor Glenn didn't say to him, hey, this is a safe spot, what you say here stays here, we wouldn't be suing the church. We would not be suing them for a violation of their bylaws. That would clearly be, that would be a non-neutral interpretation. But it's the reason he has a duty is kind of the whole combination of his position as a pastor, his position as a marital counselor, which is what he was holding himself out as, and then the express promise that what is said here stays here. And so let me just give you kind of a counterfactual. Andy Ellingson, right, who was on these emails, he's a doctor. If Andy had responded back and said, I've been treating Mr. Koster for 3 years, and let me tell you all about the treatment I've provided, and boy, he's got some real problems, you need to know X, Y, and Z, well, he would clearly be disciplined for violating physician-patient under neutral principles. And so that's by extension, Pastor Glenn is the same. When he holds himself out as a counselor, makes the promises of confidentiality, induces Mr. Koster to tell him some very confidential and private information about himself, induces Mr. Koster to even participate in the marital counseling in the first instance.
Counsel, what do you make of the argument that there's a common interest among the church members to talk about morality issues and things like that? I mean, the district court talked about that, and they talked about a security threat issue. But I'm interested in your thoughts on that first part, that, you know, what happens in the church is sort of bound up in, you know, moral action or moral duty. And does that do any work here?
Again, I understand the argument. I think what it is a manufactured attempt to get us into non-neutral interpretations of their doctrine. And you only would need to get there if you found that qualified privilege, you had to determine qualified privilege based upon that interpretation. And you don't in this case because they've exceeded it, they've abused it. And then alternatively, you wouldn't have qualified privilege because he acted in reckless disregard of the truth. So you don't need to take a look at the morality aspect to determine whether or not qualified privilege has been abused, or under neutral principles if he's breached a fiduciary duty.
On that subject, may I ask one more question? It's just a follow-up.
Messages, they're having a hard time hearing the question, so please make sure your buttons are on when you talk and get close to the mic.
All right. There is an argument made that what he put in the emails wasn't necessarily something that he learned in the private discussion groups, but was sort of something that he could have learned beyond that. What's your response to that argument?
So I think you have to parse, are we talking about the defamation claim or the breach of fiduciary duty? With respect to the defamation claim, I think there's a clear implication, and Judge Rydell kind of highlighted that in his summary judgment ruling, that Pastor Glenn is clearly identifying himself as somebody who's close to Ryan and has personal knowledge of it, when in fact he didn't. And so the implication that he molested his daughter, for example, or that he physically abused his son, or that he has some type of condition that requires, further treatment, is coupled with the representation that he's close enough to them to have special knowledge to essentially vouch for the veracity of it. So that's with respect to defamation. As for the breach of fiduciary duty, he shouldn't be telling members of the congregation that they're engaged in marital counseling at all, or that they were considering 12 steps, or that he's in a bad spot. He should not be, and then essentially vouching that he knows that information based upon his 2.5 years of a special relationship with him. That's where the breach of confidentiality comes. Thank you.
I'm sorry, I'm going to follow up a quick question on that.
Yes.
So if the pastor, if you're saying that he was being held to the marital counseling standards as well, if he had not preceded those private conversations with, hey, this is all going to be confidential, let's just say they started talking back and forth, would your argument be the same?
I think you would still have to take a look at the nature of the relationship, both being as a pastor and as a marital counselor, look at the statutes, look at the power disparity, look at the specific facts of what Mr. Koster, the trust he put into the pastor, and the relationship based on all of those factors determine whether or not it would be a breach. I think I could make that argument, but I don't think I need to, because there's a genuine issue of material fact as to the promise of confidentiality.
Thank you. Ms. Richards.
Thank you, Your Honor. May it please the court, counsel, my name is Amanda Richards, and I represent Harvest Bible Chapel and Pastor Garth Glenn. I want to start with a question that you raised about whether the information that was actually in that email came from Life Group. It is clear in the record, it came from the appellant's brief, that what they are asserting came from Life Group was that Mr. Koster had to reveal everything about his sex life, which included things such as looking at nude pictures, masturbation, and foreplay with his wife. When you look at the record, there is nowhere in any of those emails where it says anything about that. Now, this court stated, the means by which a church chooses to advise their congregation is outside the purview of the government. That's the Banster case. What is before you in this case are 3 emails that were written, it is undisputed, by Pastor Garth Glenn in his role as a pastor. And Chief Justice, you mentioned, is he being viewed as a marital counselor? The record states that Ryan Koester never saw him as a certified marital counsel.
Was he one?
No, he was not. In fact, Mr. Koester knew he was not a licensed psychologist. He did not have a seminary degree at that time. He knew he wasn't a licensed marital counselor. He also states in the record, which is undisputed, that the advice that was given in this life group is all based on scriptures. So no, it is not secular counseling. There is an option at Harvest Bible Chapel where if you want to apply for formal marriage counseling, you can do that. You fill out an application, you're assigned a trained counselor, and there's formal confidentiality documents that are signed. That is not what happened in this case.
I'd like to ask you the same question I asked Mr. Dickey towards the beginning, because it seems to be going both ways. Did the pastor proceed the conversations with, this will remain confidential?
Here's how he started it. And I agree, there's no fact dispute. What Mr. Dickey said is what was said. In small groups, they don't say confidential. What they say is, this is a safe place to share. Because the way this church is set up, they do counseling in community. So it's kind of a unique environment. They don't believe, under their doctrine of biblical soul care, that the pastor is in charge of the church. They believe the community comes together and counsels. So in this informal biblical soul care, which is done in the small groups, they sit down and they say, this is a safe place to share. So to answer your question, it's not a formal confidentiality agreement that's signed, but you're correct. It is said, what is stayed within your discipleship group, or what's called the circle of influence, is expected to stay in there. However, what was also in the record is that these pastors govern in what's called a plurality of leadership. It's kind of like I think of in my law office. If I have a case going on, I can share information with my partners and we can talk about it. One of the claims here in this case that's before you is that one pastor can't even talk to another pastor about things that he learns in this small group. All of the communications that were done, the Klebelstein case is very important here because all of the communications that were done were within the church community. Now, what Mr. Dickey wants to argue is Jim Demarest that we talked about earlier. He's trying to hold the Klebelstein opinion to formal membership because what is in the record is that Jim Demarest resigned his formal membership of the church and he had not been attending regularly at the church for several months. However, this church's practice of discipleship, in order for you to determine when that ends, you would have to entangle yourself in that religious practice. There is no requirement to be a formal member of the church to belong to a small group. Now, I'd like to remind you that in the Banster...
Can I ask you a question about...
Yes, please.
What church staff were copied on the emails that the pastor sent?
First email was to the pastors. So there's several pastors at Harvest Bible Chapel. The second email came to what's called the admins. So those are the people that assist.
Could you stay close to your mic? Sorry.
I apologize. Those are the people that assist the pastors. So as far as the staff, that's who received the email.
Why isn't there a fact issue on the qualified privilege on the defamation claim about whether the privilege was exceeded with respect to Demarest and potentially the church admins who were also on the email, and whether or not this should have been communicated to them?
As far as the admins, I'll address that first. They are members of the church. The reason why it's not a fact issue is because he's reading Klebelstein too narrow. Here's what Klebelstein says. It says the common interests of members of religious associations. It also refers to the congregation. No requirement of formal membership. Jim Demarest, Ryan Koester admitted in his deposition that he was still involved with the people of the high school leadership socially. They were still part of what's called in the church his circle of influence. The fact that he no longer has a formal membership should not break that privilege.
Aren't those somewhat separate things, though? The shield, from versus the qualified privilege with respect to a defamation claim. Those aren't necessarily congruent, right?
Thank you, Your Honor. They blend here, and that's what was mentioned earlier, because if you read Judge Fowler's opinion, he follows what you stated in Klebelstein. He says it's subject to a qualified privilege. Mr. Dickey wants to limit that to what it's known in defamation. But remember, you held in the Barreca case that a qualified privilege is simply a defeasible immunity to liability. He says it's qualified privilege under the ecclesiastical shield. That's what they also said in Klebelstein. They said there's qualified privilege, but the ecclesiastical shield was weak in there because they gave it to the public with no connection to the church.
I want to follow up on Demarest. So it sounds like what you're saying is, if the church wants to keep considering him a member, then communications can continue with him with the benefit of the privilege. That seems to me, I don't think that's what we said in Klebelstein. I mean, we don't give the church sort of the unilateral authority to protect its communications by deeming somebody who's not involved anymore as a member.
But he is involved. I think the word member is getting lost in translation. He's still involved in the discipleship practice. You don't have to be a member of HBC to be a part of that small group. The evidence in the record is that he was checking in with Ryan Koester monthly about his marriage. He was still a part of the discipleship practice. So if we have to go into, is he a member or not, that's entangling us in what does it constitute to be part of that congregation. Because in Banstra, that pastor stood up in front of the entire congregation in front of him and told them what the ladies had done. Now, he did not say, raise your hand if you have your formal membership done.
No, I recognize that my own church, we define liberally who's a member. You don't necessarily have to have given money in a while, but is there actual evidence in the record that Demarest was affirmatively involved in activities of HBC at the time he received the communication?
The record shows that he was socially involved with Ryan Koester, that he kept Pastor Garth in the loop by checking in by email with Ryan monthly for continued discipleship. That is the evidence that's in the record of how he is continuing to participate.
Counsel, can we return to the defamation claim for a minute?
Sure.
And I want to explore the scope of the privilege a little bit. And let's set aside Demarest. Let's assume he's not included and it's all church members only. Or is it your position that any statement that the pastor made to church members is subject to the qualified privilege as you're interpreting it for the
Yes.
defamation claim?
Yes, Your Honor.
So if Pastor Glenn sent an email that contains information that he knew was false, not even reckless, his purpose was to defame Mr. Koester. And as long as he sent the email to church members, your position is that is therefore qualified privilege or subject to the qualified privilege. Do I understand you right?
What was said is that if they have a common interest in a religious association, any communication between them is privileged.
Even when done with the actual intent to defame.
In Banstra, the pastor stood up and called women that had been sexually abused sexually immoral. They didn't look at what he was saying and his intention behind it. And I will say in these emails, the reason malice wasn't found is because when you read those, there is none of that intent in there. It was pray, pray, pray.
But in my hypothetical, there is. And,
Right.
as I understand your position, you're reading the qualified privilege on the defamation claim to be congruent with the ecclesiastical shield. And
Yes.
it doesn't matter what he says in the email, it's privileged.
And where I'm getting that from
Okay.
is Banstra. Because it says in there that what a church does in counseling and advising their congregation is outside the purview of the government. So that's the source that I'm getting that from.
But that doesn't require us to get into matters of church doctrine. I mean, if the record is a member of the church or a pastor of the church wants to defame another member, we don't have to look at church doctrine and get involved in that to allow a jury to determine whether or not it's defamatory, do we?
In Banstra, the way it was worded was that when it's a communication, how they choose to advise someone in what they're saying in the church is outside the purview. I can understand what you're saying in that hypothetical, which is not present here. But the way it is written in Banstra, it is that broad. That when there are communications made within that environment, it's outside the purview of the government. Now, in this one, talking about the ecclesiastical shield, I think it's important to note that when we look at a breach of confidentiality, remember this is a claim of breach of fiduciary duty for sharing confidential information. That is barred by the ecclesiastical shield for two reasons. One, you cannot determine what is confidential within the discipleship practices without looking at who's part of that discipleship group. What their argument is that when Ryan stepped away with his friends outside and made another circle of influence, somehow the group that was discipling him about his marriage and was still involved in his life, it's broken. But in order for you to determine that, you'd have to look into that. But most importantly, what Judge Fowler found is even if you find that you can determine what is confidential by secular means, a judgment could not be made telling a pastor that he cannot communicate with his fellow pastors, staff of his church, and under his religious belief of discipleship without dramatically infringing upon this religious practice.
And counsel, I think that's where the demerits issue comes back in, right? Because it's a question of membership. And if a pastor says, I think that Mick Jagger is a member of my church because I pray for him, that doesn't mean that Mick Jagger is, right? And so isn't it a factual question to determine the issue at least of membership? I mean, that doesn't strike me as getting into church doctrine, but am I wrong about that?
I think what I would say to that is when Klebelstein says a religious association or congregation, that would be what you'd have to determine. Do we call that formal memberships? Because I would argue that's a slippery slope. Because if we're going to require formal membership in order to protect communications made by a pastor with his church, then we're going to have to determine when does formal membership start. We'll have to look at the religious doctrines of
Aren't
each
you kind
and
of
every
doing
one.
that now with the argument you're making? We're getting entangled with, well, he goes to this little group, but not the other group. We're already hearing all kinds of entanglements with your argument.
I think that that's what happens, if that's what the rabbit holes we go down, is that we end up getting entangled in these practices when we look at the pastor sharing alleged confidential information.
Doesn't that sound like a fact question?
It doesn't, because you don't get past the ecclesiastical shield. Because in order for you to enter a judgment, in order for this to go in front of a court, if a judgment's entered against this court, then essentially what Judge Fowler said, and he got this from the Penley versus Westbrook case, you're taking the secular duty of confidentiality and you're saying that that is higher than the religious practice of open sharing with discipleship. So you're putting that, what he said and what it comes from that case, you're putting a fine on the religious practice. So that's where it runs aground. So if you don't find that it runs aground of the ecclesiastical shield with determining whether it's confidential, because I had to do my first summary judgment, Judge Rydell found that you can determine whether something is confidential without looking into religion. So then Judge Fowler took it that next step, which he got from the Westbrook case, and said, and this is exactly what the court in Texas said in Westbrook, that even if you can decide that, a judgment is going to infringe upon this church. And remember, this is a church where it's community over privacy, community counseling. That is what they preach within that church.
So what religious value is advanced or protected by allowing people to utter false statements against other people? I'm really struggling with the way you've framed the qualified privilege here. And it seems like you've created, or at least you've argued it, as some sort of intra-church shield from defamation liability,
No, I
right? I mean, so if Pastor Glenn, let's just say he said, I don't like Koster, and he sends an email that says, Koster stole money from the church, and he knows it's false, but he just wants to defame him. And I think your position is, as long as he says it to church members, that's privileged, right?
Now, that's not my position because it wouldn't have a religious purpose to it. I would say, to follow your statement, that if we change it to saying something that has no religious purpose.
How do we
I
know
think
it
then
doesn't have a
could
religious
come.
purpose? Maybe they like saying stuff like that to make somebody squeal on something else.
I wouldn't say that that was for, I think what it says in Klebelstein is it has to have the common interest of the religion. And in discipleship, that is sharing sin with one another to assist them.
But isn't that related to the common interest of the church, the financial health of the church? I don't see how that's different than accusing him of sexually abusing his daughter.
But the issue, number one, he didn't accuse him of sexually abusing his daughter. That's not in there. What is in there? He did not do anything like that. What is in there, what they're claiming is he disclosed confidential information regarding his marriage. But it is not in those emails. The issue of the allegations that came from his wife, who informed the church. So that's not a claim that the plaintiff is making. So I want to make sure I'm clear. I'm not saying that it can't be for a religious purpose. I am. I think the way, however, that Klebelstein and Banstra was written is that the way that we choose to do our discipleship and what the church believes we need to say is what
If
is
the
what it covers.
gist of the email was that he sexually abused his daughter, does that take it outside the privilege as you have articulated it here today?
I don't believe so because the issue that happened within the issue going on with the daughter is not part of what he's saying is confidential.
But boy, wouldn't that be an easy dot to connect? Maybe that was what was in the 232 or 236 petition, all of the business about the abuse. But he premised all of that on his close relationship, all this deep counseling we've been having. Oh, and oh, by the way, I wouldn't let your kids be near him.
But what it comes with that part of the email that Judge Rydell found was used for security purpose because he was involved in the youth ministry. So that part of what happened as far as the allegations came from Lisa Koster informing the church about those allegations.
We're just talking about qualified privilege. It's not a license. Excuse me, it's not a license to lie. I mean, it's the same privilege. I'm a public figure. He's getting the same protection that I would get if somebody said something about me. I would not be able to sue unless I proved actual malice, right?
I would agree. It's defeasible. Remember that the qualified privilege is a defeasible immunity. So if we have these issues, then yes, I would agree with you. It's not carte blanche that you can say whatever you want. What it is a defeasible immunity, but under the ecclesiastical shield, because we're speaking with the church community in a form of discipleship, it's barred from court scrutiny. I believe I'm out of time. Thank you, Your Honor.
Thank you. Well, we added to that problem, so. Mr. Dickey.
Thank you.
Madam Chief Justice, I want to be clear what the record shows with respect to expectation of confidentiality. In the appendix, page 603, at the beginning of their life group meetings, Glenn assured Ryan and others that it was a safe environment for the information and that information shared would stay between the three couples only. With respect to the Jim Demarest record, the appendix on page 604, and this is in footnote 4 of the reply brief. In his affidavit, Glenn states that Demarest informed Glenn through email that he had been checking in by email with Ryan monthly for continued discipleship with the men in the high school leadership group. That's hearsay. So that's not even admissible evidence for this court to consider when evaluating the summary judgment. They didn't put Mr. Demarest's email in directly. What the evidence is that the Demarists were not attending church, were not members. And again, so that goes to Justice McDonald, your question with respect to qualified privilege. I want to make a couple of points. First is qualified privilege is only a burden allocating device. It is not immunity. Those are separate things. So with respect to qualified immunity, what we say is that when you have certain communications for which there's a special public policy interest, then we will then allocate the burden of proving malice to the plaintiff. That's all qualified privileges. There's no partial qualified privilege. It's all or nothing. And when we look at whether or not we ought to protect those communications, we look at the interest that is to be protected. We look at what's communicated and who it's communicated to, and whether it's limited to that protected interest. So then the court would have to take a look is, why is Pastor Glenn communicating to Jim Demarest? By the way, they've not met in small group for 2.5 years. So this is not, they're not furthering the interest of small group with this communication. He's no longer a member. When I asked Pastor Glenn in his deposition, why did you send these emails? His answer is, I wanted people to know about it. And on this point, it's really important to look at the lack of symmetry in the defendant's arguments. So in the first motion for summary judgment, they tried to position Pastor Glenn as not having any type of religious interest in the life group, right? They characterized him as acting beyond the scope of his pastor duties, and they characterized life group as just couples going out and talking about things over coffee. And when they lost summary judgment on that basis, they leaned full throttle into his making these communications purely as a pastor to advance their religious benefits, religious doctrine and beliefs, because they're trying to get ecclesiastical shield.
I mean, you agree with me? I think we're on the same wavelength that the two claims need to be separated. So defamation, the issue is there a qualified privilege based on the nature of the communication and who it was communicated to? And if there was, have you established actual malice, reckless disregard for the truth? New York Times versus Sullivan, that sort of thing.
Correct.
On the breach of fiduciary duty, the issue, it strikes me, is the breach based on neutral principles of law, or is it a breach of fiduciary duty that is too wrapped up into what the standards and practices of the church are, and that we would get too involved in that in order to ascertain whether there's been a breach? That's kind of the issue there. Am I right?
Exactly. That is the precise analysis we asked the court to adopt, right? And here's where the district court got that wrong. So the district court did not, with respect to defamation, go to that last step and do the analysis of actual malice. I mean, so by definition, to be qualified privilege, the statement has to be made in good faith, right? So that issue was squarely before the district court. We argued it wasn't. And on appeal, they haven't even addressed the issue of malice. So they've waived that issue. But there's a genuine issue of material fact as to, what Pastor Glenn did to determine the truth of the statements that he was representing in those emails, which is virtually nothing. He didn't read the no contact order. For the first email, he didn't even talk to Mr. Koster before sending it. He did essentially no investigation and made these representations that he has inside information. With respect to the breach of fiduciary duty claim, the problem with Judge Fowler's analysis is that he melds in the qualified privilege into that analysis, which it's not. And when they talk about, lastly, when they talk about the Westbrook decision, what's a really important distinguishing factor there is Westbrook is a Texas decision. Texas does not recognize the neutrality principle for free exercise claims except for property damages. So that is, not only is it not authoritative, it's not even persuasive. And so because this can be decided on neutral principles, which, by the way, Judge Rydell found in the first summary judgment, we submit that reversal is warranted on both claims. Thank you.
Thank you. The case of Koster, which I thought was Koster till I heard you guys saying it, Koster versus Harvest Bible Chapel is hereby submitted. In addition, the two cases that will be submitted without oral argument are Bauer versus Brinkman and Tony versus Parker et al. Court is adjourned for the day. Thank you.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.